course shall be reserved for the local candidates, and the remaining 15% of the competent authority shall be unreserved seats as specified in the Andhra Pradesh Educational Institutions Order 1974, subsequently amended. That's the presidential order, subsequently amended. B. In respect of statewide institutions, admission into 85% of seats in each course shall be reserved for the candidates belonging to 3 local areas in the state specified in this sub-rule: Osmania University area, Telangana, and Sri Venkateswara University area, Rayalaseema. Manoj, we take it that our medical university also exists, but they're referring to it as area because the presidential order referred to those areas. In the two respectively, and the balance of 15% seats shall be unreserved seats. Explanations for purpose of these rules. The local areas means, and your lordships can now see, the part of the state comprising of all these districts is regarded as the Osmania University local area, which is Telangana. B is with reference to Andhra, and C is Rayalaseema. And now B, capital B, at the bottom of page 244.
The local candidate.
The local candidate. Candidate for admission shall be regarded as a local candidate in relation to local area. A, if he has studied in educational institutions in such local area for a period of not less than 4 consecutive academic years, ending with the academic year in which he appeared, or as the case may be, first appeared in the relevant qualifying examination. So the period of 4 years ending with is same phrase. B, where during the whole or any part of the 4 consecutive academic years ending with the academic year in which he appeared, or as the case may be, first appeared for the relevant qualifying examination, he has not studied in any educational institution. If he has resided in that local area for a period of not less than 4 years immediately preceding the date of commencement of the relevant qualifying examination, which he appeared, or as the case may be, first, what, there's something...
Sir, these rules are amended in 2017.
2017. So, in 2017...
Yes.
This very 4 years stipulation is there.
Same as presidential.
Now, this is the exact same as the presidential.
What is B?
I'm sorry.
He says that you need not study in any examination.
No, if you're, no, not that you need not. If you have not studied in any educational institution, you still have to do the 12th exam from here, which is open schooling, private institutes, etc., which are not educational institutes recognized to give you the academic.
Can you limit it to that? Because it says residence. See, a student who goes to... And they may be working for 4 years.
Yes.
In that state. He'll be entitled. Because he has been residing there.
He will be entitled.
Isn't that an anomaly? A person who is idling without going anywhere remains there.
Yes.
And a student who has gone there, permanent residencies in Telangana, he goes to another place.
To be fair, I would consider that kind of person has possibly been trying this NEET studies for the last 4 years, as people do for civil services, etc. He's been sitting there and doing it, and he's devoted it to my state. He wants to do it there. He wants to
4 years. 4 years.
4 years. I mean, it happens, Manoj. We have come with age relaxation applications before your lordship because people have done precisely that. No, there are those kind of scenarios. There are... Yes. There are...
Yes. These rules are eventually amended when? 2024. Yeah. There was a I can check that again. We have maximum. Actually, the things were stated but the children are giving the president.
Now,
Yes,
just 2 minutes more because there's some factual basis I want to tell you. These rules, which I've just shown your lordship 2017, was challenged before the High Court. A judgment came out in 2023, the year before this impugned judgment. This is the previous round, therefore. In that 2023 judgment, the court takes note of a full bench of 2003, where the court had sustained the presidential order, the qualifications, domicile, etc. This 2023 judgment, however, says you need to import the requirement of this permanent residence.
That is challenged.
2023. So they read down the provision which is challenged.
So whether that is challenged. No, 23 judgment.
2023 judgment is challenged. The SLP out of that is in this batch.
But you find them subsequent to judgment, improved hearing.
So the difference is
So between 17 to 23, what is the position? Whether that rules were straight from 17?
Was there a state? Was it state? Was the 17 state? No, it was not state. There was no state.
So what is the position?
Judgment came in 23. I'll just give me 2 minutes.
Yes.
There are 3 judgments that your lordship may note. 1, full bench of 2003. Full bench 74 on the classification regarding local area. Round 2, 2017 rules, judgment delivered in 2023. What's the date? 29th August 2023. Judgment you'll find at page 260 of the SLP paper book. The full judgment is set out. It's a writ petition that is filed in 23, not filed in 2017, filed in 23. Judgment is passed, reading down the rule and saying the directions are that as far as the provision is concerned, it will be read down to include this permanent residence. Now, please note that came.
260 is again the full bench. Division bench.
No, division bench. Now, the division bench is important because this division bench says that the provisions of the 2017 rules are paramateria with the presidential order. In which case, in our view, it should have followed the full bench. And the full bench did not make any tweaks, did not do any reading downs in 2003. But the High Court in this second round does do a reading down. If your lordships were to come just for a minute, if I can take you to that, because I want to present a full picture, my lords, rather than leave that dangling. Just 309 for a minute, if you see. Page 309 of the SLP paper book. Let's have page 309. So, tabular columns which show what rule 33 of the 17 rules says and what para 4 of the presidential order says. So, it's virtually identical. And after, at page 313, notes what the full bench had said, sustaining the presidential order. Then para 67, Malot, I'm just quickly taking you through the relevant parts. Page 317, para 67. The full bench of Andhra Pradesh High Court has not interpreted Rule 33B and C of 17 rules as 17 rules have been framed subsequent to the aforesaid decision. Therefore, the full bench of this court in Batina Raja Shilpa is not a binding precedent insofar as interpretation of 17 rules is concerned. I would take issue with this, Malot. Once the court says it's paramateria, then the same interpretation would follow. However, the interpretations put forth by the full bench of this court of paras 4.1 and 4.2 of the presidential order is of assistance to us in interpreting Rule 33B and C of 17 rules, which are in paramateria with paragraphs 4.1 and 4.2 of the presidential order. From a perusal, it is evident that the same defines local candidate with reference to study in such local area for 4 consecutive years, ending with academic year in which he appeared, or as the case may be, first appeared in the relevant qualifying exam. If I can skip to the next para 69, bottom of page 318. The aforesaid conclusion recorded by us with regard to interpretation of Rule 33B and C of 17 rules, also supported by the view taken by the full bench in Batina Raja Shilpa while interpreting the analogous provision under 4.1 and 4.2 of the presidential order. Now, after saying all this, please come to page 337, Manoj. 337. Now, I should show you page 335 before that. Page 335, para 84. We may now examine whether the aforesaid requirement of treating a candidate as a local candidate, which is based on requirement of study or residence in a local area for 4 consecutive academic years, ending with the academic year in which a candidate appeared, or as the case may be first appeared for the relevant qualifying examination, is contrary and is violative of the mandate contained in Article 14 of the Constitution of India. Now please come to 336. They have set out what the rule does, and last sentence of para 86 at page 336 says the aforesaid rule is based solely on the basis of the residence and has no rational nexus and object sought to be achieved by the 2017 rules. That is, of providing medical education to the students, including the local students. The permanent residents of state of Telangana may have cleared the relevant qualifying examination from an institution outside the local area due to reasons beyond their control, and otherwise eligible would be denied the benefit of admission to 85% of the seats in non-statewide institutions, competent authority seats, and statewide institutions merely on the basis of study or residence outside local area. There appears to be no justification for denying.
So the division may rely on their own judgment,
Yes.
which is impugned here.
So this.
And after that judgment, after the second judgment, you challenge the first judgment.
So now what is important are three things. Three things.
Yes.
First, that this rationale of the second round is borrowed and imported in the third round without bearing in mind three things. The first, from 1974 onwards, those in regions of local areas A and C, the two Andhra local areas, who were excluded from Telangana, which is the local areas in B, those are the very kind of people who are here contesting it today. Very kind of people, obviously not the same people, but very kind of people. Because the local areas were defined.
Yes.
And you were excluded.
Only one question that we are asking.
Yes.
Whether these persons
Yes.
or these candidates
Yes.
are they residents of the local area of Telangana, or they are residents of the part A and C?
A and C. Now,
Are they residents of
I'm-
Andhra and
the impugned judgment, thankfully, puts down for every writ petition where those people are. Just see it for a minute.
yes, so therefore they say local area.
Correct.
They restrict it to a local area. They don't consciously they don't permit a person who is residing in Andhra Pradesh or domiciled in Andhra Pradesh to come to Telangana.
Exactly. I am most grateful. That is precisely what we are doing now. Now,
Sanction in 2017 and 22.
the, from 1974 till
Can I please conclude?
I'll take 2 minutes. So I just want to put the point.
You said 2 minutes, but 10 minutes are over.
I'm sorry.
After that,
I'm closing this. I'm putting my file down, so I will not be prompted to show you anything else. Just 2 minutes. From 1974 till 2014, a position stood saying immediate last 4 years. That position stood. That's the same position today. There's not been any disturbance there. 2017, it comes as rules. There's a full bench which sustains the presidential order. Surprisingly, for some reason, they say, however, some injustice will be caused, therefore include, and they read down the permanent residence into 2023. The difference is, after that, we amended the rule. We brought in these new rules that your lordship saw, because
they are parameteria with the 17 rules.
the reason we did that is what we did not have in 2023 to argue, we had in 24 to argue, which is that the
Completion
10-year
of 10 years.
period had come to an end. So the minute the 10-year period came to an end, the continuation under Section 95 disappears. So I had to define local area. This time I don't define it by districts. I said Telangana is the local area. And I say this is a domicile. Now this, your lordships have done, chart other states. It's not unique only to Telangana. This occurs in Andhra, Assam, Karnataka, Maharashtra, Tamil Nadu. We have given the details, we just culled it out so your lordships can see. It's being followed in all these states without any. That's okay.
Sorry.
No, because I have to wrap up in another 30 seconds. Our simple stand, my lords, is this. I won't read it, but if your lordship were to go through the first 10 pages of the impugned judgment, writ petition by writ petition.
Therefore, we have been requesting you from beginning to show us in 2024 rules or the entire rules.
Page 347, I thought Dr. Singhvi read that. I'm so sorry. Page 347.
Same thing.
What is that number?
47. Yes. I'm sorry. Your lordship didn't see this. I'm so sorry.
You have seen the amendment, but where are the rules? Entire rules. Same.
That's a 2017. That's what I read to your lordship. 2017 amendment.
Has the amendments been incorporated and the new rule has come out? See, now here only the amendments are introduced. Amended rule is produced in page 347.
Yes.
What Milord is asking is just.
Are these the complete rules?
page 239.
That the complete rules, which including the amendments.
So I understand what your lordship only the amendments. I'm sorry, you'll have to read 239, which is the unamended rules. You'll have to do that.
That comparison is made at
The
page 120.
substitution is with reference to those
239.
cases which are in 347, 348, 349.
Unamended rules at 239.
239, yes. 239. I'm so sorry, we were remiss, my lords, in not putting out the entirety as it stands. But the amendment is particularly to this rule 3, which I showed you at the bottom of page 243. So that's what's been amended.
It is not a.
Where that amendment is, just see para 2. It says on expiry of the period of 10 years, provided in section 95 of the AP reorganization of the matter, have decided to amend so-and-so rules issued in GO2 above and are subsequently amended from time to time. Accordingly, this notification. Last thing, page 88 onwards, if your lordships were to see, this is the impugned judgment. Each writ petition, who the petitioner was, where the petitioner resided, it includes Oman, Doha, Dubai, etc. Please consider in
Let us see that.
that's page 88 onwards. It includes people in Andhra. Just for an example, Manoj, it starts at 88. The first, they say it's not stated where the residence. The second petition, bottom of page 88. She did her schooling 1st to 8th in Telangana, 9th to 10th in Andhra Pradesh, and intermediate at Vanaparthi, Telangana. So even by that Haryana maximum of 10th, 11th, 12th, she would be out. 89 middle, the petitioner submits that he has studied in state of Telangana all through, except that he had to study 7th to 10th in Dubai due to professional exigencies of his father. Bottom, the petitioner submits that she has studied in Telangana all through, but had to pursue
You see
intermediate.
the anomalous situation.
Yes.
A person has studied throughout
Yes.
from 1st to 9th in Telangana.
Yes.
Unfortunately, for 1 year, he goes to Maharashtra.
Correct.
He again comes back 11th and 12th, he does in the
Yes.
state of Telangana.
But
And she is disqualified.
I admit, I'm the first to admit, there are hard.
There are hardships.
There will be.
Hard cases doesn't make a law invalid.
Yes.
We are
So I don't-
quite appreciate this argument.
Yes, there will be hard cases. And please note, in contrast to this, there are children in Telangana who come from very, very modest means. And there are thousands of them. We have 13 lakh students in Telangana. Now, of those 13 lakh, there may be handfuls who don't do those last 4 years in Telangana for one reason or the other. But the lion's share do. Now what we are being told is, no, your 4-year rule is not good enough because of one or other reason. Please make way, telling these students who can't afford quotas and can't even afford going to Andhra, they are in Telangana throughout.
But economic criteria was never a reservation point.
I'm sorry, Manoj?
Economic criteria was never a
No,
reservation.
no, on the contrary,
It's economic-
on the contrary, the judgment restricts it to be eligible to admission. You have to be either a domicile of state of Telangana or a permanent resident. It doesn't enlarge the scope. Anyway, thank you, Mr. Shankara.
This last sentence,
No, thank you.
permanent resident is not defined anywhere.
Yes.
Importing permanent resident is the problem.
Okay.
Because we have given our definition of what it is for local area. I'm grateful, Manoj.
I appeal for 4-5 submission. Only one
Who
submission.
will you decide who is
We are-
who has been designated for first?
Same day, my lord. So lordship has
So
to.
same day, but so but in that order of seniority, who is first?
Whatever. Let him start. Whatever lordship says.
Maybe
2
excuse
points,
for
I won't make maybe.
maybe excuse for.
We have to give you the same treatment as we give to Dr. Singhvi.
I wish my clients would give me the same treatment.
Yes.
Well, that's 2 short points, my lords. The first point is that, my lords, the state cannot be aggrieved when a rule has been upheld, and then it has been only been saved by giving an interpretation to frame the guidelines.
It has been read down.
Exactly, lay down the guidelines. That is how they saved the
It has been, the rule has been read down with a direction to the state to the frame the guidelines to
my lords, define people who are permanent residents or domicile. So, my lords, there cannot be a challenge to that because this rule has been upheld, in fact. Otherwise, my lords, any other interpretation would have ensured that the rule is struck down today. And, my lords, seen in the context of the 2017 rules that has been struck down, my lords, there is every reason for people to understand that, to assume that the rule which has been struck down, they are not going to introduce it again for the simple reason that that was challenged subsequent to this order. Manoj, your lordship may kindly see the mischief here. The mischief. Now, Manoj, but during this period, Manoj, the entire case is we should have known for the last 10 years that a rule is about to come. Now that impression.
You don't have any objection if the rule is given effect to prospectivity from 2028.
28, yes, my lords. 4 years. My lords, but then, my lords, the only catch could be, my lords, that we do not know what the guidelines would be here. It would be, but for the present, my lords, definitely yes. Now, for the simple reason, my lords, what has happened is, during this period when the rule was struck down, and subsequently, my lords, when they challenged it, during this interregnum period, we were given to understand that the struck down rule would hold good.
But 2017 till the judgment came, that is in 23.
Exactly.
The rule was in application.
But then 23.
So, was the rule in application?
Yes,
Yes or no? Yes.
Yes, yes.
And you knew about it. 23, of course.
Then we challenged it. My lords, we succeeded in
There
the.
was no straight to it.
My lords, we challenged, we succeeded in the.
Yes.
My lords, the second thing is, my lords, in a similar situation, my lords, what your lordship had done, beautifully, my lords, in this, with regard to Delhi Medical College, similar situation arose where there were transfers. And,
Malti.
no, my lords, this is Meenakshi Malik.
We have already taken it out.
Exactly, my lords. Your lordship may kindly see what.
We have already read that.
So, therefore, my lords,
taken it out.
my lords, the submission is, in all the 3 conditions, number 1,
1984 judgments, etc., are in a context where this kind of migration was not that common. Now, today, lordship may see this judgment. What is the judgment done? The judgment, all that the judgment has done is, now lordship put a question. 2017 rules were there, were you not aware of the rules? Now, I'll tell you, lordship, a big difference. In 2017,
Right from 74, when the order under 371D was issued by the president,
yes,
the areas were earmarked that for A, Venkateshwara University, then B, Osmania University, and C, some other university.
I'll tell you, lordship, the difference.
And undue benefit.
Rules, when it was introduced, the local area was defined as areas of Andhra, areas of Telangana, areas of Rayalaseema. So 2017 rules up to the amendment, if suppose an example, 1st to 10th I had studied in Telangana, 11th and 12th I had gone to Andhra, I would still be a local student because I come within the definition of local area in the 2017 rules.
No.
In 2017. In 2017, quota is different.
Yeah, but under the 74 order,
Yes, my lord.
you have to do 4 years of study prior to qualifying examination in that local area.
Yes. So, Lordship, would your Lordship kindly come to the local year 2017 to 239?
Yes.
Would your Lordship kindly come to that, my lord? Just give me the
page 1 to
in one section. This is the 2017 rules. Page number. Would your Lordship kindly see the 44? This is the unamended 2017 rules. What I'm reading, my lord. Page 244, the middle of the page, the local area means. My lord, got that, my lord? Yes. Local area means, now Lordship see, A, the part of the state comprising so and so.
As is in the presidential order of 74.
Your Lordship, kindly see who's the local candidate. Please come to B. A candidate for admission shall be regarded as a local candidate in relation to a local area. If he has studied in educational institution in such local area for a period of not less than 4 consecutive academic years, ending with academic year in which he appeared or as the case to be first appeared. So, if I had studied 4 years in either Telangana or Andhra or Rayalaseema,
No, not.
Yeah.
You have studied for 4 years.
in Andhra also.
1 minute.
Yes. Well, Lordship got that? 134. The heading with object of the rule. In case a person who otherwise is a permanent resident of domicile of Telangana is excluded from the process of admission merely on the ground that he has not passed the qualifying examination from the state of Telangana, the object.
Then we have, in effect, the High Court holds that the rule is not permissible.
The read on.
There is a question of reading it down.
Next, I'm just coming. Just Lordship may see that. Now, please see. The permanent resident domicile of Telangana may have cleared the relevant qualifying examination for an institution outside the state and may otherwise be eligible, cannot be denied for admission merely on the basis of study of residence outside the state. Then the question which your Lordship put to me, whether Rule 3A has to be struck down or read down. Then now we may advert to the issue whether so-and-so rule has to be struck down or read down. Then a division bench of this court with a common order dated 23, that's a typo, my lord, it's 23. Then, Lordship may kind, para 78, the golden rule of, para 78 at page 138 bottom. The golden rule of interpretation is of respecting the wisdom of the legislature on the ground that they have legislation. In somewhat similar fact situation, Supreme Court in so-and-so judgment held that, then in Ahmedabad Municipal Corp, with a view to iron out the creases in the impugned judgment, Rule 7 of the rules therein interpreted the rule in the manner indicated in para 14 of the judgment referred to Supra. Similar view was taken by the Division Bench of Bombay High Court in Rajiv Purushottam, and Rule 4.4 of Maharashtra rules were read down to include permanent residents of state of Maharashtra. Then, para 79, this judgment is taken note of. We may take notice, then Lordship may skip that, my lord, and then extract. Lordship may come straight away now to page 148. Meenakshi Malik is considered after that. Then comes.
With regard to the parents who were compelled to go out of India as they were transferred.
Yes, Lordship is right. Then after all that, para 83, page 147. I'll read from them. Thus, the Supreme Court has held that the petitioner has no real choice and cannot continue his schooling in Delhi as a father was postulated. That is what Lordship is saying, Meenakshi Malik. Then comes para 84. An interpretation which advances the object and purpose of the act has to be preferred. The object of rule so-and-so, as amended in 2024, is to provide reservation for local candidates. In case the rule is struck down, then students from all over the country shall be entitled to admission in medical colleges situated in Telangana, and the domicile / permanent residents of Telangana would be deprived of the benefit of admission. Therefore, we read down the rule 3A and 3.3 of so-and-so as amended with AGO 2024. It is held that the aforesaid rule shall not apply to permanent residents of the state of Telangana. Thus, by reading down the rule in a manner indicated above, shall also be in consonance.
In effect, legislating.
Now,
In effect,
direction also Lordship may see.
yes.
Para 87. Para 87 of this judgment, page 150.
We have read that.
The directions, what
Yes,
they
we have read
say.
that, yes.
So all in para 87, what they say is, you state, you please frame guidelines as to when a student
We
will
have
be.
just seen that.
Yes. So now the initial judgment is of 29/8/23. This judgment is of 5/9/24. State till today has not come out with any guidelines of framing pursuant to this judgment.
We have straight down the judgment.
The Lordship has stated, but 20th September, they made a concession saying that respondents before the High Court will be given the benefit. We are all similarly situated as the respondents in that. That was interim order based on concession. I'm not in actually, my lord, it will be very
Yes,
technical.
yes, Mr. Naik. Yes.
But I am the permanent. Very difficult in the last 4 consecutive years, I was not eligible.
Where were you?
But first to 5th standard, 5th standard, I studied in Telangana. Then 6th to 10, my lord, I went to Andhra Pradesh. 11th and 12th, again, my lord, I came to Telangana. So therefore, even if a person studies for 3 years consecutively, my lord, he will not be entitled in view of this.
Yes.
Others, High Court has permitted me, my lord, to produce the residence certificate, which I have produced, and I have got admission in the college. And since last
Those of
May I just take 2 minutes?
wait, not session, maybe you're not discussing on this.
May I just take 2 minutes of your long
Yes.
time? I'm hearing for the intervener. Not one marked change between the 2017 rule and the 2024 rule is that in the 2017 rule, there was the reservation for local candidates only to the extent of 85% of the intake. Students such as us were available to be absorbed in the 15% non-local category if we were otherwise residents of the other local areas, which your lordships will find at page 239, which is the 2017 rule as
Yes,
is.
we have seen that, yes.
Now, my lords, in the 2024 rule, the entire non-local category has now been taken out and the entire state of Telangana is the local area and the 100% of the seats are reserved only for the locals of the state of Telangana as now introduced. The Rule 3E, which allowed for a sprinkle amendment rules. Therefore, there is a change of what was prescribed since 1974, what continued up till 1923, and what was sprung upon in 2024. Therefore, the residents of Telangana or the state of Andhra Pradesh were not unreserved category would also be entitled to be admitted, and therefore their movement outside for a period of 2 or 3 years would disentitle them completely out of the entire intake. Now, my lords, this is one reason why the implementation of
No, 15% is available to everyone from the country.
No, kindly see, my lords,
No, 15% you are entitled and also another person from another state.
No, just making this submission because this is my intervention petition. This is my pleading in the intervention petition that is not denied. Kindly see 2017 rules as they stand, my lords. At 239. Kindly see the reservation percentages prescribed. Kindly come to.
Saying that 15% has to be for all India quota.
Kindly
It's under the judgment of this court, Mr. Counsel.
Yes, my lords, and now that,
Yes, is the reservation.
that has been taken out.
Reservation for 85% or 100%.
Listen, my lords, 85%.
They can't do it, Mr. Counsel.
My lords, may I just indicate your lordship? My lords,
They can't do it.
that state.
That's the judgment of the Supreme Court that all India 15% is an all India quota.
Yes. Now, my lords, by reason of reference to this particular rule, which is there at 242, kindly see as to how the reservation percentage had been worked out at 243 and as to how this has been deleted under the impugned rule. This has not been noticed by the High Court, my lords, nor was perhaps a plea raised. Kindly come to two.
Then you should have challenged the judgment of the High Court. You can't intervene and.
My lords, I'm only pointing out that this rule.
Yes, thank you. Yes.
Just kindly have page 245. There's something very important I want to point out.
Yes.
In the 2017 rules, because 24 is far more onerous.
What is your good name?
Krishna Manas. Krishna.
Yes.
Your Lordship will kindly have page 245, paragraph C, because local candidate has been defined in 2 tranches. You kindly see C, after the first paragraph. A candidate for admission into the course who is not regarded as a local candidate under clause A in relation to any local area shall, if he has studied in educational institutions in the state for a period not less than 7 consecutive years, ending with the academic year in which he appeared, or as the case may be first appeared, be regarded as a local candidate in relation to, this is important, such local area where he has studied for the maximum period out of the 7 years. And now your lordships may kindly see at 244, local area here has been defined separately in Telangana, Andhra and Rayalaseema. So just to give your lordships an example, if I have studied 1 to 10 in Hyderabad and I have studied 11 and 12 in Vijayawada, even then I would have been a local candidate because clause C comes to my aid insofar as the 2017 rule is concerned. But if your lordships now has...
Less than 7 consecutive academic years, ending with the academic. So, you had to study for 7 years, maybe from 7th standard, 7th, 8th, 9th, 10th, 11th, from 6 years, 6, 7, 8, 9, 10, 11 and 12.
Correct, my lords. But then thereafter, your lordships may see clause A, and it says such, because that says state, and then it says such local area where he or she has studied.
Who are you?
My lords, I am one of the respondents, my lords.
Studied for 7 years in other states. Are you appearing for somebody who is from Andhra Pradesh and has studied for 7 years in the state of Telangana?
No, my actually.
Then don't argue what.
My
Don't argue for what is not factually your case.
My lords, kindly, I'm not made myself clear. Just give me 1 moment, because I'm so sorry. All I'm saying, my lords, is this local area definition is in 2 parts. The first part, your lordships are saying 4 consecutive years, right, my lords? I don't fall within that. The second part is slightly more expansive. It says 7 years among different local areas if I study, then...
Not among the different local areas. So 7 years consequently in the local split.
Correct, my lords.
So they felt that the other people also should be given a benefit.
Correct.
In 2024, they feel that now no more.
Yes.
We'll only have it for state of Telangana.
The only thing I'm saying is, in 24, it's far more onerous. So this is only on the perspective.
And in 24, the experience they garnered over the years, they feel that now we are confining it to Telangana.
Yes, my lords, but I'm just saying, your lords, then none of us will have any notice, my lords. In 2017,
Yes.
My lord, I am born in Telangana. For 7 years, I've studied in Telangana. Due to my father's private job, I was forced to move to Vizag. 8th, 9th, 10th, I studied in Vizag, my lord. 11th and 12th, I studied in Telangana. That is against lordship. I'm very in a connected SLP. I studied for 10 years in Telangana because my father is working in a PSU. The exact thing
In my case, in favor of all the respondents, I was not given an opportunity. All other students have got it. And on the border itself, so that the reason is that I am a permanent resident. I am a
Father lives 5 kilometers
5 kilometers away from the border
of Telangana in Andhra.
Andhra Pradesh.
Okay.
2 years. That
Yes, Mr.
Your lordship,
My lords,
in my case, Telangana. Otherwise, she's permanent resident of Telangana. Your lordship.
Manoj, I'm appearing for some of the respondents, Manoj, and also in the High Court I had appeared for the respondents who are the petitioners in the High Court, Manoj. As your lordships have repeatedly noted, Manoj, during the state's arguments, the entire purpose, Manoj,
Yes, we'll consider that.
yes, Manoj, I'm only trying to submit, Manoj, that residents has a...
Yes, thank you. We are heard you. Yes.
Manoj, 1.7 is a writ petition against a rule in Andhra, not even a rule, a university
We
rule.
are referring for whom?
State of Andhra, my lords, it is misconceived. My lords may detag and dismiss 1.7. My lords, it has nothing to do with the
Did I correct them?
Obliged.
Just let the learned advocate general have a last word.
Oh, yes, of course.
What fell from your lordships on the last occasion that provision should be made for military services and IAS officers and central government employees working outside the state or came into the
Or
state.
those who have come to state.
We have made, if your lordship so feels, this is what we would.
And also for the defense personnel.
Yes, Defense is also mentioned.
And PSC. Paramilitary forces.
Mentioned. It's also mentioned.
Thank you.
I have a 2-page written note.
Give it by Friday. If you want to give anything additional, anybody wants to give written submissions by Friday afternoon.
Lordship, just one final thing with respect to the relief. My lords,
After the learned advocate general, nobody can answer.
my lords, just
After the learned advocate general, nobody can answer.
my lords, not an argument. My lords,
Thank you.
My lord, permit me to make a request. It is in other item, my lord. It is,
Thank you.
my lord, it's in 1005.
Yes,
My lord,
thank you, Mr. Babu.
my lord, this is a different case, my lord. In this
Then
case,
did I get different as a redaction?
1005.
my lord, the only issue is that previous year's counselling was made subject to outcomes of the orders of this honorable court. So that may be considered, my lords. Appropriate reliefs may be given
Thank you, Mr. Counsel. Thank you.
My lord, I'm sorry, my lord, it's a 1005 separate art. My lord, it says, my lord, the impugned order says to take the possession, my lord, of the residential houses even without the payment.
What matter you are arguing?
This is different one, no, it's a different matter. 1005, my lord.
It's a medical matter.
No, my lord, it is
Yeah,
the matter.
what is this?
I'm sorry, my lord, it is. My lord, it's a review item, my lord.
Arguing in the midst of a board.
My lord, at the requesting, it's mentioning, I am making.
Measuring at 110. Where are you practicing?
My lord,
Where are you practicing? Yes. Close for order. Look, Sangan, I'll give you a piece of advice. Yes. Thank you very much, Sangan, and convey our thanks to Dr. Singhvi also. Thanks to all of in absentia. Yes. Next, madam.
Item 2. The repeated attempts, my lords, by the government of India to modify illegally the EIA notification.
Huh?
Yours, yeah, wait one letter. Come. You are next matter starts. I have a suggestion.
Go, go.
Very well.
తెల్ల జుట్టు ఆయన ఏం మాట్లాడట్లే ఆకలి వేస్తుంది ఆకలి మన వాళ్ళు గట్టిగా మాట్లాడుతున్నారా తెల్ల అదే చూపించారా డేటా 85 మెంబర్స్ది చూపించారా
చదివాడు కానీ ఫస్ట్ది తప్పు చదివాడు రెండో తర్వాత